Whoa, where'd it go?
I'm taking us live on YouTube. I will.
Huh.
Okay, we are live on YouTube and I have put the recorder on so we can go ahead with beginning the meeting.
I have
Oh.
a message. I have a message on my screen saying this meeting is being live streamed.
Yes.
Got it?
Live
Got
stream.
it?
Yes, you
Click
can.
on, click on, got it?
Yep. It's
Okay.
live stream on YouTube. That's the YouTube stream.
Okay.
Okay. Christopher Close, I'm just going to rename you very briefly to make your name a little easier to read. That's all for anyone watching from home. Okay.
Sorry.
That's okay. I think we Kate, we are ready to go ahead.
Okay, wait. Go.
Kate, are you there?
I think she might have just clicked off.
No, I don't see her anymore.
Uh-oh. Oh, here she is in the waiting room.
There she is.
Technology. Okay. Connecting to audio. Can you hear us, Kate?
Okay, yeah, I'm sorry.
There we
There
are.
you are.
Okay, sorry, hit something wrong. Okay, so we're here for the March 9th, 2022 ZBA meeting. We'll start, and the first item is who's here? I'm here, Chris Carney
I'm here.
and Chris Close.
Present. Thank you.
Okay, so we do have a quorum. And the first item on the agenda is the approval of the, excuse me, February 9th meeting minutes. Does anyone have any corrections or additions?
None. Thank you.
Do not have any.
Okay, so I move that those minutes be accepted.
Second.
All in favor?
Aye.
Aye.
Aye. Okay. I just want to say now, at the close of the two public hearings, we will revisit the issue of the required escrow amounts in light of the recent events. We said we'd do that, but we will do that after the public hearing so that we don't delay anyone with that internal proceeding. Okay, so the first item on the agenda is the public hearing for ZBA 22-02 for the Castiglionis. They have an application for 2 area variances for their property at 7 Whales Back Road. The first is to get a variance from the required 35-foot setback. Section 143-68E of the zoning law requires a 35-foot setback, and they want to have only a 10-foot setback. And also they have a request for variance to increase the gross floor area for their proposed cottage to 950 square feet.
84.
984 square feet, sorry, thank you. Okay. And did we have anyone who indicated they wanted to participate in the public hearing?
No, I will state for the record, I received no email, no letter, no direct phone call, and no voicemail regarding this public hearing. So I have had no communication from anyone. And I did receive the certified mailing receipts back. So the public hearing notices were received by the neighbors.
Okay, and the escrow issues was taken care of?
Yes.
Yes, it was this morning or this afternoon.
Okay, great.
And one of our neighbors did
Well,
tell us
both-
that they
no.
received the email
Go
or
ahead.
the letter.
Donna and John.
Oh, I guess both of them did.
Mhm.
So
Yeah.
those letters were received.
Okay.
Okay. So to the applicants, do you have anything additional that you want to discuss with the board before we start our deliberations? I'm sorry, we need a motion to open the public hearing, right?
I so move.
Second, all in favor?
Aye.
Aye. Okay, to the applicants, again, anything that you wish to discuss or elaborate on your application?
No, I think the only thing that we sort of left sort of open-ended at the last one was one of you guys pointed out that there was an opportunity maybe to take our current garage and morph it into an apartment and then to build a separate garage, which would be disconnected from the house and would eliminate the garage versus cottage argument. And we've come back to the idea that I don't want this apartment to be connected to the house. I would like this to be, as the cottage is, a separate facility, and so that doesn't meet that need. And
We
the
also
way our
use-
garage is structured, because even though it's probably large enough, it doesn't allow passage into the house.
Right.
And it has a built-in staircase to the bottom of the house, so it's actually much smaller than the square footage that's stated. Because I can't, I'm not going to take out that staircase and make it disappear.
Right.
So that, just to clarify, that doesn't, it's not that it's an impossibility, it's that it doesn't solve all the problems the way the proposed building.
Okay. Okay, Chris Carney or Chris Close, do you have any questions or comments for the applicants?
Not really. No, thank you.
No, I don't have anything. Thank you.
Okay, I just want to say, if either of you were out there this afternoon around 5 o'clock, I was the car that pulled up to look at your property.
The one that we opened the
Oh,
garage door for.
I thought somebody would come out, but I was just, I just wanted to be there for a second, so.
Okay, so
Does that answer that
I
mystery?
heard a car and I opened the garage door and then you turned around and I was like, okay. I was
'Cause
so confused.
I thought I heard a voice, but nobody came out and
Yeah.
it,
We
you know,
we have a babysitter with the kids, so we could give you our undivided attention. And she arrived like 2 minutes after you did. So I opened the garage. I thought it was the babysitter, and I was like, all right, she's taking a minute to come in, and then you disappeared. And I was like, wait, that's not our baby. That's not Miss Sam's car. Okay, sorry, I would have come out. I did not. I was expecting the sitter.
That's fine. I saw what I needed to see, and I'll just report that the applicant's home is built up on a raise. It's a slight raise, and the surrounding property slopes down from that. And then it seems to go off into even lower, almost marshy
Marshy.
land.
Marsh. It's
Very much.
very wet.
Yeah, so I just wanted to stop by because you had not provided any topographical information or anything, but you testified credibly that it was a wet area, and I just wanted to make a visual confirmation, and that
Does the
appears to be so.
normal
So,
Blueprint show that?
It does, but not in as much as it is
Oh.
now.
Okay.
okay. So even with the snow, it was clear, and I got a sense of how close the adjacent property is to the proposed site for your garage and cottage. So, okay. Well, if there's no comments from the board or the
Oh, I just want to ask,
Sure,
what was your
Chris.
impression when you looked? Kate,
at the property, at the
property.
house.
yeah, next door.
Oh, next door? It's quite close. I mean, on the maps, you could see, if it was my property, I might not be so happy to have a neighbor constructing close, but these people apparently have no issue with it, so.
It's not close to their house. It's close to their property line, just to make that clear. It's not like they're gonna open their window and look at a garage cottage. It's just our property line is like a flagpole, so it's driveway and then square, and theirs is very similar.
Yeah, theirs doesn't
So
apply. It's a long
our
rectangle.
driveways are very close, and we're building the proposal for the garage cottage is close to, like, you drive up our driveway into said garage, and so obviously that line is close to their driveway. I don't know if I'm articulating that
They've
clearly,
you
but
are.
seen it because we went through
Okay.
the map. But the
I just didn't want it to sound like we're building this like it's going to be an eyesore when they open their
Yeah.
curtains in the morning. That's
because
it's-
their house doesn't even point to look in that direction. It's sort of tangential.
We've also intentionally not put any windows that would be facing their house in the blueprints for the garage cottage to give that additional level of privacy to them.
Anything else, Chris, you wanted to ask?
Well, thank you.
Okay. So I guess we can move ahead to consider, close the public hearing and move forward to consider the variance resolution. I move to close the public hearing.
Second.
All in favor?
Aye.
Aye. Okay. So we do have, does everybody have the draft? I'm looking,
Yes.
sorry, I'm looking at the Bathricks. That's the wrong one. Where's, thanks.
I just want to check with Victoria. Victoria, are you gonna fill that out as they go? I always take notes, but Victoria?
Yeah, I'm here. Sorry, Patrick, I was just sitting back.
Patrick is there.
Yeah, are you gonna fill that out as we go? Like,
I'll pull up the resolution and fill it out as we go. Yes.
okay, great.
Okay, so the draft variance resolution we have includes, it's just one resolution for both of the area variances. So, but I believe that we should consider them separately because there's different considerations to these. And I suggest that first we look at the setback variance that they are requesting.
Anne, can you let me share? Sorry to interrupt.
Yes, of course. Hold on. There we go. Yes, go ahead.
Okay, oops. I'm sorry, I gotta,
Okay, there it is.
okay. So first we have to consider what testimony we've considered and pertinent facts that we've noted. I would note that the applicants have testified credibly that the location of their septic tank and the wetness, the marshy areas of the property considerably reduce the possible locations for additional structures. And that the site that they've chosen appears to avoid those problems. And I would note also that on my site visit today, I did observe that the front of their property faces out into a large front yard. They've indicated that they would like to keep that view open, and the placement of the structure to the side next to the driveway would make that possible. And although I guess as a third point, although public comment isn't determinative, I would note that there's been no opposition from neighbors, and that this lot is, from my observation, at the end of the long narrow driveway for a flag lot, and the visual impact on the neighborhood would be minimal. Okay. Mr. Carney, Mr. Close, anything you want to add to that?
I don't think so. I think that's good.
I don't have anything to add. No, thank you.
Okay, so now we can look at the criteria for number one, the variance requested, and we are talking now about the setback variance, will not produce an undesirable change to the character of the neighborhood or a detriment to nearby properties. I would agree with that.
I agree.
I agree also.
The needs of the applicant cannot be achieved by other than an area variance. Again, needs are very subjective, but in this case, the applicants are looking to build a garage to accommodate all their equipment and vehicles. And they have shown that there are limited locations for this structure. And I would agree that their needs cannot be achieved by other than placement
I agree.
I agree too.
in a way that requires an area variance.
Mhm.
For number three, the requested variance is not substantial. It is a substantial variant. It's a 71% reduction of the setback requirement.
I agree.
Yes, I think it's substantial.
It is not substantial. I mean,
It is.
it is substantial. Yeah,
Okay.
double speak again. Yes,
Right.
it is substantial.
Okay, the requested variance will not affect the physical or environmental conditions in the neighborhood. I think it will not.
I agree.
And five, the hardship for which the variance is sought to rectify is not self-created. It is self-created.
It is.
Yes,
And the variance being granted is the minimum variance to meet the needs of the applicant. I will credit their testimony that it is.
I agree.
yes.
So can we get a motion to approve
I
the
move that
variance
we
application?
approve the area variance.
I just have a question for Victoria. Since we're considering these variances separately, how do we do that on the one resolution form, since there's only one part that says grant or deny? Victoria?
I think we should have two forms, and
Sorry, thought Patrick was gonna chime in.
Yeah.
We're gonna do two resolutions. I crossed out the one section on this one,
Okay,
and then on the next one, I'll add it back in.
okay, all right, great. So I'm sorry, go ahead, Chris Close, with your motion.
I move that we accept the, I move to, that we grant the area variance as noted.
I'll second.
all in favor of granting the area variance for the setback? Aye.
Aye.
So we can, that variance has been granted. And now we can move on to the second, the request for the 984. I keep losing the exact, for the larger size cottage.
It is 84.
Okay. Okay, pertinent facts. I would note that the testimony that and the town records that I've looked at indicate that the residents currently live in a 2,860 square foot home, which they occupy at 2 adults and 2 children. I think those children are both not yet in primary school, correct? Is that correct?
One is and one isn't.
Okay, so younger children. So we have 4 people occupying a 2,860 square foot structure. Okay, and second fact I would note is that the testimony has been that the proposed cottage will be used for entertaining guests, including family members and friends. Okay. Any other pertinent facts that the board thinks should be noted?
I do not have any. They seem to be the principal facts.
Good.
Okay. Okay, then we can go on to consider the criteria. Number one, the variance for the additional size will not produce an undesirable change to the character of the neighborhood or a detriment to nearby properties. And
I
I would
agree.
agree, it will not produce an undesirable change.
I agree.
I agree.
Okay. And I don't know if it's clear. I agree with that. The number two, the needs of the applicant cannot be achieved by other than an area variance. And here again, I'm going to say that I find this difficult. One person's needs or another person's, want, something that they would like, an amenity. And in this case, I just cannot accept that there's a need for a 984 square foot cottage. 650 feet is allowed. I think that's adequate to entertain guests. The applicants live in a large home. It's only a 4-member family. And so although I feel uncomfortable saying what anybody's needs are, in this case, since it is the job of the board to do so, I will say that I disagree. I believe that the needs of the applicant can be achieved by other than an area variance.
I'm under the impression that it
I'm
was
sorry.
discussed at-
I'm sorry. This is now the public meeting is closed. So this is just an opportunity for the board to discuss the application and make their findings. So I do apologize, but I have to cut you off. Okay, Mr. Close, do you have any comments or anything you want to discuss about this?
I think, it could be done in another way, but it can be achieved in another way. I agree with you, Madam Chair. So,
Okay, Mr. Carney?
I'm going to disagree and say I think I'm going to agree that the needs of the applicant cannot be achieved other than the area variance, simply because I read the definition of need as what they tell me or what they tell us during this meeting. I think
Okay.
they know better than we do, so.
Okay. Moving on to number 3, the requested variance is not substantial. It is a 42% increase over the allowed square footage, so I would say it is substantial.
I agree.
I agree.
Number 4, the variance will not affect the physical or environmental conditions in the neighborhood. I agree it will not.
It will not. I agree.
Yep, I agree.
The hardship for which the variance is sought to rectify is not self-created. I think it is
It
self-created.
is self-created.
It is, yes.
And the variance being granted is the minimum variance to meet the needs of the applicant. Well, since I am of the opinion that the variance should not be granted, I would say it is, the variance requested is not the minimum required to meet the needs of the applicant.
Yeah, I agree with you, Madam Chair.
Mr. Carney?
It's a tough one. I think I'm going to agree on this.
Okay.
I would agree with you.
Yeah, and just, I mean, we've gone through these points. I just want to make it clear that I think the board, it's as I said before, assessing somebody's needs is difficult, but clearly the questions are set out in such a way that there is an option where we say that this is not truly a need. And in this case, I think that where the use of the proposed structure is simply to entertain guests, that this would, to allow this would set a precedent of accepting whatever an applicant says as their needs. And clearly the ZBA must be, we are in a position to make some judgment of that. Not a comfortable position, but it's one that we must do. And I am very hesitant, and the reason for my opinion is that I think it would set an unfortunate precedent if we were to allow this when the need is simply for entertaining guests. Okay, can I get a motion, or we need to vote on whether the variance should be granted or not? In
Hi,
favor of
Kate.
granting?
Before you
sorry.
move on to the vote, I just wanted to clarify that the way the resolution has been drafted with regard to whether or not they need this and can't be achieved by means other than an area variance, there was a disagreement among your board members, but as drafted, it reflects the majority view right now. Depending on a vote, we can change this or rewrite as necessary, but just wanted to clarify that that's what the resolution states at the moment.
Okay. So we now need to vote on whether or not to grant the variance, correct?
Correct.
Okay, so all in favor of, well, let's just do it. Mr. Close? Aye or nay on granting the variance?
Sorry, so Kate, it's a resolution to deny as drafted. So you would be taking a
Wait,
vote.
I'm sorry, it is, where is it as drafted? Tell me. Maybe I'm not reading the second page. Where is
Look up
it?
on the screen.
Sorry.
Look.
Oh, you,
She wrote it as we.
oh, you
went.
did it. I'm sorry, you changed it as I wrote. Okay. Thank you. I wasn't
yeah.
watching that. I was reading the copy in my hand.
It would be a motion to adopt the resolution. Which
Okay, thank you.
would deny the
Thank you.
variance. And then if that doesn't pass, as Patrick said, we would change it or, redo it.
Okay, thank you. I didn't notice that you'd mentioned. Okay, can I get, so now we will vote on whether to accept the resolution as written to deny the variance. All in favor of denying the variance? Aye.
Aye.
No.
Okay. So the variance is denied. Okay. Can I get, that's the end of the agenda.
Hold
Hold
item.
on.
My apologies. Could I, Mr. Carney, could I confirm your vote? Did you intend to vote to deny the variance or to grant?
Grant.
I thought the resolution was to deny the variance.
And then you voted no, meaning
Correct.
that you didn't want to deny.
Correct.
Correct.
Okay, so then the motion fails because we are a 5-person board. You need a majority of the entire board to adopt anything, which would have been 3
So we're
votes.
in, so now we're nowhere.
So the motion did not succeed. You haven't.
We haven't decided.
Yeah.
Oh, right, yeah. So where does this put we haven't granted, we haven't denied, and what do they do? The applicant has to have some,
You
We have
haven't
to get
granted
another
or
member?
denied. We could try reworking the resolution to see if there is some sort of analysis that we can all agree on and then vote to grant or deny it. But because there's only 3 of you, it would need to be
you're
all
right,
3.
you're right.
We have closed the public hearing, which means that I believe we have 62 days to officially vote on this. If you wanted, we could postpone the vote till the next meeting if you don't think anything is going to happen tonight. And perhaps our office could try drafting something that reflects everyone's views that maybe we could get a 3-0 vote on. But at the moment, all we have is a closed public hearing.
Right, thank you. I don't think that tonight we're not going to accomplish anything. I think we've got a fundamental disagreement on how we should consider this. And I mean, certainly anything's possible, but I think we should move on to the next public hearing. Unfortunately, leave the applicants
We
in
understand.
without a resolution.
I just want to
You've
chime
got your
in.
area variance, so you can proceed on
Appreciate
that.
We do.
So,
I just want to chime in real quick. Again,
Yeah.
sorry to interrupt, that if the 62 days I mentioned does pass, then it is a denial.
Yeah.
So we should try to get something on the books within those 62 days, or else it just automatically is denied.
Right, or
Is there an opportunity for us to further discuss?
The next public hearing.
Yes,
We
we
can
could,
Closed.
we could table this to the next meeting, and the applicants could speak again. However, if we were going to do that, I would recommend that the board consider actually continuing the public hearing to that.
I think
meeting
that's
as
what we
well,
have to do
rather
to
than
avoid new
just
notice
closing it.
requirements. So we can go back if you feel that you want to speak at the next meeting, and we'll go back and we'll just move to continue this public hearing.
Wasn't the public hearing closed?
It was.
So
It
you'd have to
was.
schedule- you'd have to
Can we now
schedule
go
it-
back and
you'd
change
have to
that?
Schedule
Victoria?
a new public hearing.
We can't go back and amend our
If you
prior.
closed it,
Only we could convince you now.
I'm sorry, Victoria. So we have to do,
let me,
Okay,
sorry, let me pull up the rules. This doesn't happen all the time. We can come back to this, but at this point.
if we could
um,
possibly avoid having to renotice, that's.
No,
the-
you cannot, you've closed the hearing. So the
Okay.
hearing is closed. We
Okay,
can talk, I'll look at the rules about setting a new hearing. And we can bring it up in a little bit, but I'll look them up while you, Patrick and I will look them up while you are on the
well,
next.
do we necessarily need a new public hearing though, simply to have the applicants continue to address us? We don't, do we?
No, the applicant, right, the information they presented is the same, so you can have them speak at the next meeting.
Yeah, so we wouldn't have to continue. We'll just, you'll just know that at the next meeting, there won't be a public hearing, so your neighbors and the public at large won't be able to speak, but you certainly will be able to address the board.
And then we'll have to have another public hearing after that, or you guys will just have to have a vote?
I don't think we need another public hearing, as long as the information is that they're presenting is essentially the same, or it doesn't.
So, sorry, the situation
Victoria.
we're in, right
Yeah.
now, you need 3 members of the board to grant a variance. You
Right.
don't have that.
Yes.
Right.
So there's no requirement that you take this up again within 62 days, but you've expressed a willingness to do so. There's no need to set, the applicant's not going to present new information. So the question is whether, one of you will be convinced to change, 1 or 2 of you will be convinced to change your vote. If you don't have a revote within 62 days, it will be de facto denied.
Okay. So maybe at the next meeting, the applicants can attend, and Mr. Close, Mr. Carney and I can discuss our relative positions and see if there's something.
Yeah, keep in mind, you have to deliberate on the record.
Right, exactly. That's why I say we
call
will.
this a discussion and a vote on the agenda then, Victoria, is that correct?
Yeah, you can put it on the agenda.
Discussion and vote.
Well, you can't require the board to vote again,
Oh,
but
then just discussion. It's not a review, it's not a public hearing, so I will call it a discussion. Okay. And do you see any need for the board to schedule a special meeting of some kind, or an attorney-client meeting of some kind for this, or,
That would be better.
No,
okay,
if we can't come to an agreement, we've got the 62 days, we'll finalize
okay.
the matter.
Just for
Oh.
clarification, at the end of the 62-day period, the denial will be on that's what will happen. But
It's as a matter of law, it's
as a
denied.
matter of law,
it's
whether we
denied as a
have-
matter of law, but the
whether we-
finding,
whether we have a 5-member board or not.
right, because it takes three people, because you have a board that should have 5 members, even though there are
Right, I
2
know, but
vacancies.
shoulda, coulda, woulda, that's what my concern is.
Victoria, if we, in the next 62 days, get more members, do we revote?
You can.
Okay, I just wanted to know if that,
So what we'll do, because again, this situation comes up rarely, I'll put together a memo, just a quick, procedural memo
yeah,
on what the rules are for handling this application moving forward.
okay, thank you. Okay, it looks like we're ready to move on to the next public hearing, which is the Bathricks. It's a consideration of, it's ZBA 22-04, also an application for 2 area variances. Is this still the case that it's still 2 area variances or that are being requested?
Yes,
Okay.
one is a side yard, front yard variance, and one is a area variance for more lot coverage than what is allowable.
Right, yeah, okay, I saw some correspondence about a change in that.
But yeah, we took away the side yard variance ask.
So you did take away the side yard variance?
Yes,
Okay, so you're
We have
only
a-
asking for the property coverage variance?
and the front yard variance.
Okay. Okay, so we have 2 area variances. The first is for the placement of garage in front of the proposed dwelling. 35 feet from the front property line on the subject parcel at 81 Country Club Drive. Zoning law stipulates that an accessory structure project no closer than the principal structure or meet the required front yard setback of 60 feet. And the second variance regards the construction of a number of buildings on the subject parcel, resulting in maximum building coverage of 11% and a minimum open space of 72%. The zoning code requires that there be a maximum building coverage of 7% and a minimum open space of 80%. Okay, and as I understand it, before the meeting, you'd like to make comments to the board?
Yes, we did make some changes from what we showed you last time. We took some of your comments into account. So I thought if I could share my screen, I could show you what we've done. We also have some pictures of the existing neighborhood to show that ours is not out of character for what is there.
I have it on share screen, so you can.
Thank you.
What we received from Ann in the package is the current set of drawings, yes?
Correct. You got the drawings. So the property, as you know, is around Shook's Pond. We are proposing a house, a detached garage. We're placing them in a way to allow for our septic fields, our well, the existing maple tree and some other trees to remain. We've been granted our adjacent area wetlands permit from the DEC. So they have given us the permission to build the pool and the pool house and the patio jutting into the wetlands buffer. We listened to what you said last time and moved our garage further away from the neighbor on the side. So we are no longer asking for a side yard variance. We are asking for a front yard variance. It wouldn't really require a front yard variance because it's 35 feet for an accessory structure. However, there's that separate zoning law that you cannot have a garage in your front yard. So that's the issue. That's why we are requesting that front yard variance. And then the lot coverage is the other issue that we're covering. So if these are the pictures of the property, which I showed you last time, with the tree that we want to keep, which is sort of driving a little bit of our building placement. This is the site plan, which you have and I've showed you. This is a bit of a mock-up of the new house between the two neighbors. Because it's flat and it doesn't necessarily show you everything. I also have a 3D model of the building if you want to see that, just to kind of see what the house looks like a little bit on the property. This is the back that would be facing the pond. The street is up here, as you can see. The garage placement is, in the front yard setback. So that is the reason for that variance. Driving around the neighborhood, you can see that there's a lot of garages that are in the front yard of the house. So there's many, I'm sorry, let me make that big enough so you can see the whole picture. So this is just driving around that loop of Country Club Drive. There's many houses that are set in, therefore close to the pond, and then the driveway is up front, close to the street. There's many examples of this that I took some pictures of here just to show you where the house is further away, and I'm just taking these right out of my car window. And the garage is in almost all cases much closer to the street than anything we are proposing. We're proposing 35 feet from our property line, which is already not the edge of the street. But you can see that some of these were much closer than that. You know, this is my window of my car right here. So the next thing I wanted to show in the pictures driving around the neighborhood is that many of the structures are also covering much more than the zoning 7% maximum of building lot coverage. So we would not be out of character by the coverage that we are proposing. It's a very densely developed place. The houses and the buildings are very close to the street in a lot of cases, like you can see here. There's a lot of buildings, you know, houses have many detached buildings, so they have sheds and pool houses and garages covering a lot of their property. I think that part of the reason that this is appropriate here is because there's a huge amount of open space around these very small lots. So these very small lots are densely developed, but what you have, you know, so this is the zoning map, this is the neighborhood. You have these teeny tiny lots that are densely developed because you have all of this open space around it, the golf course on the outside of the loop and the pond on the inside of the loop. So it's sort of a planned community of cluster housing before there were words for that sort of thing. And when the zoning came in and made it RD3, it really didn't take into account that these lots are not remotely 3 acres. In fact, the Bathrix lot is a double lot at 0.6 acres. Most of the lots are half that size. So that was everything I was going to show you. I mentioned we got the DEC adjacent area permit granted. And I do really feel that the variances we're asking for, while they might sound substantial on paper, 35 feet versus 60 feet for the garage to this front line, it's very in keeping with the character of the neighborhood. So that's what we think.
Okay, thank you. Can I get a motion to open the public hearing?
I so move.
Second.
All in favor?
Aye.
Aye. And did we get any word from any member of the public?
Yes, there was one gentleman. I will read his brief email into the record. He sent an email this morning at 7:21 a.m. His name is James Mort, M-O-R-T. We wish to inform the Zoning Board of Appeals that regarding the application for 2 area variances by Gregory and Elizabeth Bathrick at 81 Country Club Drive, we have no objection. As it is, there is hardly a home in this community that would not need at least 1 variance if it were to be built today. Respectfully, James and Patricia Mort.
Thank you. Okay, if that's it, we can close the public hearing. I move
so
to,
move.
okay, second, all in favor? Aye.
Aye.
Okay. So we can go to the variance resolution. First, any member of the board have any questions for the applicant or the architect?
I do not.
I do not.
I have a question. You said there, what are the 2 variances that are being requested? I thought it was 3.
It was 3. It was going to be a side yard, a front yard for the garage, and then it was going to be the
But it's still a front yard.
7% instead of 11% instead of 7% coverage.
Okay.
I think they've lumped the open space and the coverage into one. which,
Okay,
right? Is
that's what I
that-
was, that's what I was concerned about. It
Because
didn't seem
they're
to be.
pretty much related, right?
They are related, absolutely, yes, okay.
Okay, so I have a question, since we have again, the two variances. Victoria, should we be or Patrick, should we be considering these separately and run through the criteria separately, or do it?
It's
as
up
one?
to you if you think that they're related, or if you think you can address everything in one document efficiently, then by all means, you can discuss everything in one resolution. However, if you think it's clearer to address them one at a time, we can do what we just did with the Castiglione application.
I believe that we can do it, do them jointly. I think one document is sufficient. Mr. Close, Mr. Carney, do you have any opinions?
Oh, I agree. They can
I
be
think that's fine.
consolidated.
I think they're so
I would
related
just
that,
note that you should be sure to discuss both variances each time you go through one of the 5 factors.
okay. Okay, as to the testimony that we've considered and pertinent facts that we would note, I would note, I first, is Country Club Drive that goes around that your property is next to, is that a private roadway?
Private, yes.
I thought it was, yeah, okay, I just wanted to make sure. I would note that this neighborhood is, and this little group of houses, as pointed out on the map, are all off a private road. That the only people that go by it are people that are going to the golf course, or residents of the area, or their guests.
Right.
So that the visual impact on the community at large is minimal.
I think
And
it's. Go ahead.
And I would also say that I again drove by there today because just to refresh my recollection, and it is a very eclectic neighborhood. The building styles are all over the place. The garages, as pointed out, are sometimes right up on the Country Club Drive on the road, and the proposed structure and allowing placement so as to preserve the old tree is, I would find that it's in keeping with the characteristics of the neighborhood.
Is it appropriate to note that as well, the development was put in about 50 years before Red Hook's first zoning came into effect?
Is that a question?
Oh,
Well, it's
yeah,
being
I
verified
think
now.
Victoria is putting it, yeah.
Yep.
I think the first zoning law was 1971.
71, I thought it was 72, but
Well,
I defer to you.
Splitting hairs.
I mean,
that's close enough, 71.
yeah, it
72.
is.
Okay. Nice, okay. Okay, I think then we can go on to consider the criteria first. As to the the front setback variance. The variance requested will not produce an undesirable change to the character of the neighborhood or a detriment to nearby properties. I believe it will not.
Agree.
I agree.
Okay, and wait, well, okay, now I'm confused. And the second variance, I believe also, as to the maximum building coverage, I believe it would not produce an undesirable change.
Agree.
I agree.
The needs of the applicant cannot be achieved by other than an area variance. Again, needs so
That
subjective,
means again.
but accepting that they they need it in this kind of weather that, and given the age and the purpose of this, which we got testimony was an age in place home, a forever home. Need for a garage, I think, is there, and the configuration of the lot and the trees, I would agree that the needs cannot be achieved by other than an area variance, both the coverage and the setback.
Agreed.
Agree.
The requested variance is not substantial. Let's see, we're going from what?
I would say
didn't
the requested
number.
variances, right?
I'm sorry, Chris?
Would you say, just rewrite that to accommodate both variances and say the requested variances are?
Sure. I agree that even if they were numerically substantial in impact, they are not substantial.
Mm-hmm. I agree.
Yes.
The requested variances will not affect the physical or environmental conditions in the neighborhood. I believe they will not.
I disagree. I think they'll improve them. They're saving a maple tree.
Okay. They will not negatively affect.
Right.
Okay.
Agree.
And the hardship for which the variances are sought is to rectify are not self-created. They are self-created.
They are.
Yes.
Okay. So we now have to vote on the
Are
variance
we on
resolution
the
to
s-
approve
Are we
the,
on the sixth and last point?
are we done six? Where's six? I'm sorry. Thank you, Chris.
You're welcome.
And the variances being granted are the minimum variances to meet the needs of the applicant. I
Yes,
believe that they are.
I agree.
Yes.
Okay. And so now we have to vote on a resolution to grant the two variances. All in favor?
Aye.
Aye.
Aye. Okay, Ann, did you get that?
Yes, just as we always say, conditional on payment of all fees and escrow and any other approvals that they need, which apparently they've already gotten, the DC approvals.
Okay, great. So now that's it. Thank you, folks.
Thank you.
And we're gonna go on and
Richard.
consider some internal workings.
Thank you
Yes.
very much.
You're welcome.
Thank you.
Thank you.
Thank you.
Thank you.
And now I'm going to take a
Thank
minute
you.
and just, I'm going to ask Ann to just very briefly tell us, we had asked, we considered previously upping the escrow amount, and we said we'd revisit that as information came in and new experiences occurred. And tell us briefly what happened and why you feel that we should go ahead and up the escrow amount to $750.
So we have already streamlined the process to, instead of asking each applicant for a separate check to cover the cost of certified mailings and public hearing notices, we just take that from the escrow account. But we are finding often that we have to go back and request an additional deposit. The timing is tricky because we generally don't receive the attorney invoice for the prior month's meeting until just before the next ZBA meeting. So for example, next month, the meeting is not till the 14th, so there's more time. But this month, the meeting was on the 9th. I did not receive those invoices until today. Now, the attorney's office sent them to Kathleen Flood, who's the planning clerk. She forwarded them to me today. It just so happens that our bookkeeper is on vacation. Otherwise, I would have received them earlier, but I found myself at the very last minute having to send out invoices from last month to the applicants along with a request for an additional deposit. So when I'm going, I feel that when the ZBA is going to request an additional deposit, it is helpful to provide those invoices and a balance sheet so that each applicant has a very clear picture of why they are being asked to make an additional deposit. The timing is difficult. This is supposed to happen before the public hearing. And I feel that the problem would be largely avoided if we just requested more escrow upfront. And of course, any unused balance of funds, a voucher is submitted to the bookkeeper, who then cuts a check and mails it to the applicant. So, anything that is not used is returned. And,
And I also I want to point out for everyone, just because there's two attorneys on the meeting tonight, but we never bill for two attorneys. The billing is only just for one attorney. You just get the benefit sometimes of having two for training purposes or whatever reason. But the time is really just mostly spent at meetings. It just, we never know in advance how much discussion there's going to be on a particular application, or whether there's going to be 10 people show up to a public hearing or no one.
Right.
And those are the sorts of unknowns that, just result in a particular file having more money spent on it, because we could have a 2-hour public hearing or we could have a 5-minute public hearing. So, what Ann is suggesting is just collecting a little more upfront to try and cover for those contingencies.
The other thing the board discussed, and I just want to make sure this is very clearly on the record, it was suggested at a prior meeting, why don't we raise the fees? And I for one, am not in favor of raising our fees, because that spreads the increased cost to every applicant. And there is a big difference in costs, administrative costs and legal costs, for someone who just wants to put a shed in and needs a variance for, say, 5 feet or something. I'm making this up, a very simple, straightforward application. And someone who has a very complex application. I mean, we've seen applications that have as many as 4 variance requests. And so that, to my mind, that is more fair, that the person who has the more complicated application assumes the greater cost, but a higher fee means that the greater cost is also passed on to the person who has a very simple application. And
So all we're considering here is changing the timing of payment. There's no increase in fees. It is simply for, because we have part-time staff, to lessen the administrative burden on the town and the last minute rushing to get things done, and also to minimize the inconvenience to the applicants, both of whom tonight had to come in this afternoon with checks to cover the cost for the public hearings tonight. So we asked to get some more evidence on whether the increasing the escrow was needed, and told me what had happened today. And so I thought it was appropriate at this time to go ahead and reconsider this and maybe take a vote. Comment?
I think it's much more efficient to do it that way. It's a one-stop shop. Everybody understands this when you're building something, either a shed or a driveway or a house or an addition, that it costs money. And if you can't afford $750 these days to put up your castle, forget about it, because it all gets returned to you. So yes, let's vote $750 for the escrow account and leave the fees alone, which I think is a politically adept recommendation. Thank you, Ann, for all of your hard work.
Mr. Carney.
It's going to cost over $1,000 then to apply to the board.
Again, if you're building,
it's a matter of timing. The costs are not changing. It is simply a matter of timing.
right.
So somebody may be.
The costs now are $500 for the escrow and $300 for the application for the fee.
Right. And so the escrow amount will be increased, but any amount that's not used will be returned. So it's a matter of they have to have it
Okay.
up front.
They just won't earn any interest. I mean, interest rates now are what, 1%, 2%? I'm
Less than
just
that.
joking, but we're not a bank, so too bad.
Mr. Carney, do you have any comments? Are you okay going to, okay.
I
So
just have one question. The increase in the escrow, I'm just concerned that might scare some people away, or is that not going to be a concern?
well, we talked about that before, and it may, it's just a matter of, I mean, the costs are not changing.
Right,
Right.
but we don't have any way to gauge potential applicants that might be turned away, right?
Well,
Well,
True. The other
we never,
option,
with the amount that we charge now, we don't. I mean, it's, what we
Yeah.
can tell every applicant is that they are going to be paying for attorney's fees and that we cannot predict what those would be. We can, as Ann said, a bigger, more complicated application or multiple variance requests for multiple variances will be more complicated and is going to probably cost more in terms of attorney fees. Other than that, there's uncertainty as part of the process.
Yeah.
How often does it happen that the current escrow of $500 is inadequate?
It
and
really
so
depends on
the issue is not usually that the 500 is inadequate. The issue is that when we get to a meeting and let's say there's only $50 remaining,
You're
and
going over. Yeah.
Anne doesn't want to be in a position before the meeting of not knowing if there's enough. So then she asks for additional money in case the application takes more than half an hour that night.
Uh-huh.
And where we have in the past, Ann's pointed out to me, where we have not had sufficient money, we've had applicants that stiffed us. We did, and I mean, the goal is not to end up paying attorney fees for our applicants.
Stiffed, yeah, I understand.
They did not pay.
I mean, it's a tough situation because yes, it does make it harder for people to come up with that initial amount of money, but the town board made a decision that they wanted, they wanted applicants to pay for consultant time instead of having, in order to have an attorney at the meeting. So
How about refunding all the fees in the case of an interpretation when the board decides that the zoning enforcement officer was wrong?
that never happens, Bob.
That's right. I forgot about that.
So, I mean, to answer your question, Chris, I mean, if, the 500 certainly looks more palatable than 750 up front. But if I have to go back and ask them for that additional $250,
I get it.
this difference is really none.
I understand, yeah.
except there is a difference, and that's the cost of you for a headache, and the cost to us of your time and the disgruntled
Administrative.
people. So I think this is a win-win vote.
Okay.
I mean, just for the record, our fees were set in 2015, the current fees, and they have not been raised since then, even though the other costs, such as the certified mailings and the public hearing notices, have increased substantially. So, I mean, our fees.
How do our fees compare with other municipalities?
Well, I don't know at the moment. I can't answer that.
Well, Bob, you live in Rhinebeck. What are the fees there? Do you know?
I have no idea.
I don't have it on immediately available, but
Wait a
either our
minute.
last meeting or the meeting
Wait a
before,
minute. Did you just come in?
No,
Or
I've
have you
here the
been
whole
sitting
time,
there silently all through this business?
enjoying it. Yes.
Well, you weren't announced. Your presence was announced, and I didn't
well,
see
it
you up
was.
there.
I got
Oh, I came
title
late.
and
I
name right on my
apologize.
screen.
Bill Hamill, nice to see you, for
Nice to
goodness
see you,
sakes.
Chris. Always nice to see you. What I
Same
was going
here.
to say is there was an analysis on
Building, that's
a
right.
building permit costs done between Rhinebeck, ourselves, and one other, and it's a part of the public record from either the last meeting or the meeting before. But I would say, as Ann said, fees have not changed in 7 years. And it's not just your fees, it's building permit fees. It's a variety of things. And,
Sure.
you know, there is inflation. And so we are taking up, at least examining that and discussing whether their increases should be appropriate. I would also say regarding your escrows, I'm one of the people that signs the vouchers. We're pretty efficient about returning money to applicants when there's money left in the escrow. We don't, you know, we don't sit on it. It doesn't sit and earn interest in our bank. I mean, as soon as the matter's concluded, you know, we sign the vouchers and the checks go out. So, you know, I recognize that it may seem visually like a lot more money. The fact is they get any money that's left over, they get back.
They get it back.
Pretty quickly.
Okay, so, well, let's go ahead and take a vote and see what happens, okay?
I
all in
move that
fa-
we accept the new fee of $750 as the minimum escrow fee,
Okay, it's, okay,
whatever.
all in favor? Aye,
Aye.
okay. Okay, we've done that, and I think that concludes our business.
Motion, just before we go, we did have the
Sure.
opportunity to look up that section of the town law regarding zoning board applications. So the section's 267A 13B of the New York State Town Law. And it says, if there's a default denial, I'm going to paraphrase because it's wordy. If you have a default denial, any member can make a motion to amend the failed motion or resolution and vote on it again within that 62-day period.
Oh,
So
okay, I
There's
remember.
not
yeah, I
a
remember.
requirement that you put it on the application and vote again, but you know, a member can bring it up. You can change the motion or you know, however you want to do it as many times as you need to by the time we get to 62 days.
So that means it's kind of like a hung jury.
Yeah,
And you can
Right
do
now,
it and do it. And if I want to change my vote at some point, then I would do that.
mhm.
Or just make the resolution in the affirmative, right?
That's what I was wondering about.
Okay.
Well, if you make the resolution in the affirmative, we could do that. Of course, if no one changes, if
Well,
the
yeah.
votes just get swapped, that would fail as well. So,
Yes.
you know, you guys will have to think hard about the facts and see where you're at in a month.
Okay.
I mean, of
Okey-doke.
course, the benefit to having a written resolution one way or the other is that the board has a stronger record in the event that either the grant or a denial is challenged. It's better to have, you know, a resolution with your thoughts on it versus a hung jury. But
Mhm.
you know, you all did a very good job of putting your thoughts on the record into the minutes already. So
And it's strictly on the facts.
yep,
Yes.
always is.
Strictly on the facts.
Is the decision that you prepare, Victoria, charged to the escrow?
Yes,
Well,
and
for
so
attorney fees,
keep-
yeah.
to keep the cost down in Red Hook, what we do is we don't actually prepare resolutions for run-of-the-mill residential applications. We use that standard form and we fill
Form,
it in
okay.
during the meeting. That's
As you
In-
just did.
as
yeah.
opposed to preparing them, you know, and spends time preparing it.
Yep.
But as opposed to my office preparing a written resolution before the meeting, which would add cost. We do it on, you know, more complicated applications or commercial applications. But for, you know, run-of-the-mill residential ones, we do it at the meeting using the form that we prepared previously.
Yeah, seems to work well. Okay, well, I just take a minute to say, Patrick, thank you for your service.
Yes.
Yeah,
Good
we're
luck
gonna
to
miss
you.
him.
Here.
Oh, thank you. It's been a pleasure.
Okay,
Okay.
okay, good night, everyone. Thank
Good
you all.
night, everyone. See you
Now,
next
now
month.
you guys are stuck with me or Chris moving forward. So.
We have to have a motion to adjourn, Kate.
Oh, right. Oh, yeah, sorry. Thank
Oh.
you. Did you move, Chris?
Oh, of
Tudor?
course. I always, or was it Chris Carney? I don't.
I let the Chris's
One
move
of the
to
Chris's
adjourn.
moved.
I'll second.
All in favor? Aye.